But this is much different. He's not a victim here. He was totally wrong that he had the right to have those documents. Those documents are among the most sensitive secrets that the country has. They have to be in the custody of the archivist. He had no right to maintain them and retain them. And he kept them in a way at Mar-a-Lago that anyone who really cares about national security, their stomach would churn at it.
This is a disgusting mark on American history for the future to come by these bandits in the White House, by the Democrat Party that don't play fair anymore. They don't want to just win elections. They want to take control of this country. They want one-party rule. And they have used the Department of Justice and the FBI to get what they want.
Welcome. I'm Paul Viollis, and this is Fact-Based News, a 30-minute docuseries centered on the issues keeping Americans up at night. So, if you're one of those folks that's tired of opinion-based, politically spun news, and you want to focus on the facts of major cases affecting you and your families today, you're in the right spot. Today, the Trump indictments, but more importantly, the Trump indictments and what they have to do with your personal safety. Now, you're probably saying, what do the two have in common? We're going to talk about that today. And this whole thing starts with this series of questions. So this is what we're going to do. Number one, we're going to talk about classified documents. What are they? And so that you clearly understand the charges that have been brought forth, and more importantly, what classified documents are and as they pertain to your personal safety. Second thing, what do they have to do with your day-to-day life? And this is something that I have seen over and over again in the accounting of this indictment that has not been imparted to the general public. So without question, we're going to hammer that out today. Three, was the president entitled to have those records? Now, whenever we deal with a major legal issue, we're fortunate to have Vincent Ancona, FBN's legal analyst. He's going to break this down in greater detail. I'm going to start with giving you some benchmarking information and, most importantly, some information on what classified documents are and how they lead to this indictment. We're going to talk about what the Espionage Act is. Now, that's important because, like most folks, people haven't read the indictment. As a quick sidebar, you can always go, and I encourage you to go to factbasednews.com and go to our website in our library. All of the documents from today, like in every other episode, as well as the actual indictment, will be in the library. So by the time we finish today, I assure you, ladies and gentlemen, you will have all the information you need to have a solid understanding of this indictment, political opinion aside, and most importantly, what it has to do with you. What is the Presidential Records Act? Now, we keep hearing that talked about constantly. We're going to explain that, and we're going to lay that out for you so you can see it not just on the screen, but again in the library, because it's a centerpiece for this case. And probably the biggest issue, President Trump, victim or villain? By the end of this episode today, I think you can have a clear understanding as to where that is. But I want to preface it with this. Even though we know that President Trump tends to be a lightning rod politically, and we get that, this is not a personal thing, whether I like him or don't like him. I could care less. He's not a friend. I'm not going to hang out with him. What this is about is the integrity of the United States. What this is about is protecting and defending the Constitution. And the overarching issue of you, your children, your family, and what this whole case has to do with you. So, breaking this down a little bit more, let's get started with the facts. Facts number one, what are classified documents? Now, classified documents are broken down into 5 categories. And I will share something with you real quickly. When I was a young guy, obviously a very long time ago, and I was sworn in under the DOD, the Department of Defense, during the Desert Shield era. One of the things that stuck out more than anything, and that's a lot given the amount of training and education, et cetera, and et cetera is probably the key part of that statement, that I picked up over the years with the government, was just how seriously we as the United States government take classified documents. Let me break this down for you real quickly. Starts with top secret. Top secret, and you'll see this on your screen, refers to national security information and material which requires the highest degree of protection. The test for assigning top secret classification is whether its unauthorized disclosure could reasonably be expected to cause exceptionally grave damage to national security, hence the connection to you and your family. In the indictments, the U.S. Attorney's Office is going to articulate how they feel the president has compromised that. Secret. Secret refers to national security information or material which requires a substantial degree of protection. Notice the change, one level down. The test for assigning secret classification shall be whether its unauthorized disclosure could reasonably be expected to cause serious damage to national security. One step down. Confidential refers to national security information or material which requires protection, but not to the degree of top secret and secret. Sensitive information, the loss, misuse, or unauthorized access to or modification of that could adversely affect the national interest. One step down. And unclassified information, things that you can talk about in public. Information that does not require safeguarding. So you've seen it on your screen. It will be in our library. But that is the benchmark of this case. Why is that the benchmark of this case? Because the allegations brought forth in these indictments speaks to these documents. There are tangents that will come out of that, and Vincent's going to discuss that. But clearly, that is the benchmark of this case. So hold on to that. The next thing is we talk about the Espionage Act. Now, if you look at the indictment, and again, you can go to our library. In the indictment, the president is charged with the following charges. Now, I am not going to get into this. I am not an attorney. I can't offer legal advice. I'm not that smart. I wouldn't do that. That's why we have Vincent Ancona, Fact-Based News' legal analyst, who's going to join us in a couple of minutes. He'll break this down. But I want to kind of tee this up for a second. So stay with me on this, because this is important. He's charged with, remember, this is the U.S. attorney. Remember the old phrase, don't make a federal case out of it? There's a reason for that. Because the federal government, as Vincent, I'm sure, will tell you, painstakingly handpicks the cases they move forward. Rarely do they lose because they're very certain when they pick one up, they're going to come out a winner. We'll get into that later. 18 U.S. Code 1519, which is the destruction, alteration, or falsification of records. 18 U.S. Code 1512, tampering with a witness. Now, there have been allegations and alleged information that points to tape recordings that allegedly the United States Attorney has in its possession, presenting that as a charge. We'll see. If so, I'll ask Vin when he comes on, but I'm thinking damaging, first word that comes to mind. 18 U.S. Code 1001, knowingly and willfully making false statements. Difficult to get out of that one. 18 U.S. Code 793, gathering, transmitting, or losing defense information. Drill down on that, and let's look at the screen. Which information the possessor, in this case the president, has reason to believe could be used to the injury of the United States. Willfully communicates or willfully retains the same and fails to deliver it upon request of the United States. Last, 18 U.S. Code 2, aiding, abetting in any crime makes you a principal. Okay, this is what he's charged with. So what did we start with? We started with the breakdown of what classified documents are. Benchmark. 2, go to the indictment. This is what the president is charged with. Last but not least, the Presidential Records Act. And it states that the United States shall reserve and retain complete ownership, possession, and control of all presidential records. Requires, not suggests, requires the president to assure the performance of official presidential duties is adequately documented, and that documentary information and materials be appropriately maintained. This is their case. So when we look at this, ladies and gentlemen, what are we looking at? We're looking at the first time a president has ever faced this in the history of the United States. We are looking at something that can alter the history, the future of the United States, and change our history to a certain extent. but we're also looking at something, if this information was compromised, I or no one else has any idea how that could have and may very well have impacted you. So without further ado, I'm going to switch this conversation over now to FBN's legal analyst, Vincent Ancona. Vin, thanks so much for joining today.
Paul, thank you for having me.
Vin, you and I have talked about this, and notwithstanding the plethora of experience that you have in dealing with federal court, in dealing with the United States Attorney's Office, in analyzing cases. But when you gut check on this one before we get into some questions, when you first saw this, what was the first thing that came to mind?
What the hell was he thinking?
And do you I ask you that, Vin, because so many other attorneys with experience in working in the federal court system, in the U.S. court system, have said the same thing to me. So I'm going to start off now, and let's jump into some questions for our audience to really get a good feel for what's going on. One, briefly explain the indictment and the laws that it contains.
It's a 37-count indictment. The majority of the indictment is 31 counts of willful retention of classified documents. The remaining charges are conspiracy, withholding records, corruptly concealing records, concealing documents on the federal investigation, a scheme to conceal, and making false statements. So that rounds out all 37 counts. And if you take them all together, Paul, based on the federal guideline system, he's facing about 400 years in jail. I mean, that's a stupid number, but that's the reality of what he's facing based upon all of this.
Needless to say, something that should be taken extremely seriously.
This is the case that should keep him up at night, literally.
Okay. So now, that being said, what's the prosecution's specific burden of proof?
Well, it's a burden of proof like any other criminal case. It's beyond a reasonable doubt. They have to convince a jury that beyond a reasonable doubt that President Trump and his co-defendant committed all these acts.
Okay. Your experience as a defense attorney, would you say there's a gross disparity relative to dealing with a district attorney's office in Nassau County or New York County as opposed to dealing with the U.S. Attorney's Office in a federal case?
Absolutely. When you're dealing with the U.S. Attorney's Office, you're dealing with the big leagues, Paul. You're dealing with the major league players in the legal world. To give you a statistic, the federal government convicts 95% of the people that they indict. That's a massive number.
Right. So suffice to say, and in my time with government, suffice to say, then a lot of people meaning layers within the United States Attorney's Office, had to approve this case going forward before anybody knew about it. Fair statement?
Absolutely, because you have to say to yourself, Paul, this case is going to get the scrutiny of the year. No one is bringing this case half-cocked on the gun. It's just not going to happen. The reality of it is that so many people had this pass through their hands, they crossed their T's and they dotted their I's. And I'm not saying any case isn't beatable. Every case is beatable. But they really took the time to put this one together. And the majority of this case, which we'll talk about in a minute, it's not really a question of intent or motive. It's a question of did he or didn't he. It's that simple.
Okay, so that being said, let's jump right into that. Is it intent? Is it motive? Did they have to prove either one?
On some of the counts, you do. And some of the counts, like obstruction of justice or lying or concealing, you have to prove intent and motive to be able to get those charges to come across. But the majority of the case, the 31 counts of holding on to these documents, it's not necessarily intent or motive that's necessary. It's really just the simple fact that it was done.
So you're talking basically constructive possession. Was he in possession? Was he not?
Period. End of sentence. Absolutely.
Okay. So that being said, now let's switch gears for a second. Pursuant to the Presidential Records Act, was he entitled to be in possession of the documents?
Per the act, no.
Okay.
It's really that simple, that he has to, and a vice president has to turn over all documents at the end of their term, at the end of their administrations. That's just the way it works. Now, if he would have declassified certain documents, he could have been in possession, other people could have been in possession of it. It would have been fine. But the reality of it is the documents he's charged with in this particular case have not been declassified. So therefore, the Records Administration would have had the right, legally, to retain them immediately at the end of his presidency.
Okay, so that being said, as we're laying this whole thing out, I know that if the United States Attorney's Office is currently, and we know they are building a case against President Trump, then would this then also apply to any other president vis-a-vis our current president, President Biden, for the allegations that were brought forth against him? Or is this more focused on Trump?
You want reality versus fiction? The fiction of it is it's everyone. Everyone is entitled to the same scrutiny for documentation. Reality, I feel like it's only Donald Trump at this point.
Okay, so this is a really important part of this conversation because, you know, the whole mantra behind our show, Ben, is our fact-based news, right? So forget about opinions, forget about politics. And a lot of people said to me, Paul, how are you going to do this show and stay out of politics, right? How can you talk about anything regarding former President Trump and stay out of politics? Because we're just looking at facts. And you have done a great job right now breaking down the laws we have, the material elements that have to be met in order for this case to move forward in a serious way against him and for the U.S. attorney to get a conviction. But now the piece of information that we need to come as a national community out of this is, does this apply to everybody? Will all presidents be scrutinized? Will vice presidents be scrutinized? Or will the president sit back now as a defense and say, this has nothing to do with anything other than me, meaning President Trump, and it has nothing to do with anybody, no other president, even though you know that they've done it, you're just coming after me. Do you think that's something we're going to hear from his defense?
I think that's probably the only good defense that he has in this case. And like I said, Paul, the issues of obstruction of justice and hiding and concealing, I feel like they're fact-based. You can figure out whether a person tried to do something or not. But the simple fact that these documents shouldn't have been there, it's very hard for him to get around that. It really is. He needs to be able to put forward a defense that I declassified these documents. So it doesn't matter if I kept them in the bathroom, the kitchen, or anywhere else. But I don't think he's going to be able to do that. And we know that there are certain witnesses in this case where he's acknowledged that he didn't do that. And that's going to be the biggest problem for him moving forward.
So as a reasonable defense, as his defense attorney, and I've heard some statements on this, will be brought up. Do you think it's foreseeable they're going to turn around and say, well, wait a second. If this is a crime, pointing their finger back at the United States Attorney's Office, why have you not pursued charges against current President Biden?
That sounds great, Paul, in theory. And you can run that defense in a courtroom if you're sitting there with a jury and the jury wants to take that opinion in the case. But if the jury's getting their jury instructions from a federal judge who's going to explain to them that under the Presidential Records Act, that specific document in his possession at any given time where it was not declassified is an absolute offense, it's going to be very hard to spin it any other way.
And that was where I was going with this, Ben. That's where I was going with this. Because obviously this is a slippery slope. Obviously these are very, very serious charges, as you pointed out in the genesis of this conversation. This is why I wanted to go down that road, so that everybody sitting there thinking what I just said was able to get the benefit of that, of your viewpoint on that. Because at the end of the day, quick sidebar to everybody listening right now, it's important that you kind of clued in on what Vin just said. Even though you may be sitting there saying, look, they're targeting Trump. Okay, and I said in the beginning, highly political case, I get it. Whether or not they're targeting him is not going to be permitted by a federal judge in here. The federal judge is going to keep the United States Attorney's Office, and they're going to keep the defense attorneys for President Trump on point. Correct, Vin? Keeping them on point. Very little latitude. Is that accurate?
There's going to be no latitude on this. It's going to be an absolute fact. Paul, you know what I can equate this to? People talk about jaywalking. Everybody jaywalks. No one crosses at the corner. Everyone crosses sometimes where they can. Anyone can be arrested for that at any given moment. It's a question of which officer decides to arrest you for that. Your defense cannot be, there were 3 other people jaywalking on the same block. All they have to say is, but you're the only one we caught.
Right. Which is another example, right? Everybody listening can relate to it. Almost everybody can listen. Driving down the road, you get pulled over for speeding. There's 5 cars that are ahead of me. Well, I missed them. I got you, right?
And that's Donald Trump.
How important, Ben, is witness testimony and the audio tapes we're hearing about right now? How important is that?
I think it's the whole case against him. I mean, I really do. I honestly, you have to say to yourself, the defense that he would have would be that he said, I declassified these documents. He would have to run with the theme of that. Now he's caught on an audio tape, someone wearing a wire on him saying, well, you know what? I didn't declassify that stuff. If that's true and that's accurate, and they're able to pinpoint that when he says the words, I didn't declassify that, and it's in reference to the documentation that he's holding on to, it's an admission of guilt on his own part. And that's going to create 31 counts of this indictment to be found guilty against him.
Okay, last question. And I know this is something that everybody's thinking about, Vin. I know it's something that I was thinking about the first time I saw it. And probably unlike a lot of people, I'm sure, like you, first thing I did was I tracked down the indictment and read the indictment. And I remember telling my wife about this in conversation. Once I read that indictment, I said, this is a bad case against them. I mean, this is a very serious case against them. And I don't know how he gets out of this one. You know, I really don't. So that being said, last question, if convicted, what's he looking at?
In totality, about 400 years, and I'll break it down for you, okay? The 31 counts of the willful retention of the documents is basically punishable up to 10 years on each count. The 3 counts of withholding and concealing documents are 20 years each. On the 2 counts of false statements, 5 years each. And the 1 count of conspiracy is another 20. So now listen, I'm giving our listeners and our viewers an understanding that there's a totality of 400 years. Would he ever get that? No. But that's what he's facing.
If he's convicted, in reality, there are federal sentencing guidelines. If convicted, first time a president, et cetera, et cetera, et cetera. I'm not going into opinions of what could happen. Based on your experience dealing with the federal sentencing guidelines, if convicted in even a fraction of these cases, these charges, what do you think he might get here?
Well, let's put it this way. He's
experience.
convicted on everything across the board, right? Let's say he's really facing 400 years under the federal sentencing guidelines under its maximum terms. The judge in a federal case has something called downward departure. It allows the judge to look at the totality of the case and make a decision on what he wants to do. The judge can also go upward depart. The judge could give you more time. The federal system, even though it has a federal sentencing guidelines, which gives you a range, allows the judge the freedom to go up or down. In my opinion, a federal murder indictment usually ends with a 23-year plea. So using that as a benchmark of probably one of the worst things you can be convicted of, where do you think this would sit in a federal judge's hands? I'm of the opinion that if he's convicted, he's either going to do no jail time or 20 years. There is not going to be anything else in between.
Well, you know, not to coin the phrase, Vin, but I guess the jury's out on that one, right? We'll have to see.
Absolutely.
Well, listen, as always, Vin, I can't thank you enough for taking the time. Ladies and gentlemen, fact-based news legal analyst Vincent Ancona. Vin, thanks so much, and we'll be catching you next week, I'm sure.
Thanks, Paul.
All right, Ben. Listen, we're going to switch right now, and we're going to go to audience questions. And we got a question that came in from Gail in Tucson. And Gail writes, as she is a concerned mom of 2 teenage girls. And she writes a question that I really found, we got several, by the way, which was really cool and very, very on point to this. But she writes a question and says, Paul, what do I tell my 14 and 16-year-old daughters about how these documents could affect them in their future? And I thought that was a very powerful question. So Gail, let me break this down to you real quickly, right? 1, great question. 2, when we talk about top secret information, we are talking about information that shares trajectory of risk from a nuclear attack, our current military plans, chemical, biological, radiological, nuclear attacks, strategic positioning of our assets, our human beings, our intelligence operatives that gain information that preemptively protects attacks from America going forward. So much of this is done on the front end, so much that wonderful people like you will never see the maturity of that risk because it's done on the front end. If these were compromised, if they were compromised, and that information, our secrets that keep you and your wonderful daughters safe, if that was compromised, only God himself knows what kind of risk they could be facing in the future, because we don't even know whose hands that could be in. That was a great question, and I really appreciate it. And everybody, again, your show, write us, info@factbasednews.com. Send us your questions. Gail, great question. Now, at this point of the show, I'd like to turn to the board. The board where we wrap up what we talked about during this episode. Really solid information, and granted, a lot of information. I almost kind of invoke something that one of our executive producers, Smith Glover, had said to me once when we were talking about legal information. And he said people kind of, they're uncomfortable with it because it's difficult to handle, and I completely understand that. So you've seen the information we talked about on the screen. You've heard Vincent's breakdown about just how serious this is and what the charges are. Now let's go to the board and let's leave you with the information that you need. One, to understand the gravity of this case, and also to understand what it has to do with you. Very important. Number one, safeguarding classified information has everything to do with your personal safety. Remember we talked about from top secret to secret documents and the information that they possess that can adversely impact the safety, grave danger towards Americans on American soil, grave danger. So that is how serious this is, and these documents are, that the president that it's been alleged that the president is in possession of or was in possession of. That's how serious that is. Number two, under the PRA, the Presidential Records Act, the official records of the president and his staff are owned by the United States, not the president. This is a very, very important point. And I ask you to take a second on this. The President of the United States, the leader of the free world, the most powerful position and distinction on our planet, does not have the right, regardless of what president it is. This is not about Trump. This is not about Biden. This is about any president. You do not have the right when you leave office to take. There are procedures to follow, and the allegations here is those procedures were not followed. And these documents, as I explained to you how serious they are in his possession. Very important to understand that. These documents, according to the Presidential Records Act, are the property of the United States government. 3, did President Trump know or had reason to believe the material could be used against the interests of the United States? Now, I'm taking that language right out of the charging document, right out of the indictment. They're going to have to show that. That's going to be tough to show. He's going to have to show that he knew he had these documents. Granted, as Vincent said, part of that is in constructive possession, which they will fight that part. And this is the other component. Did he know or had reason to believe? That's going to be key. 4, was there intent to harm the U.S. government? Now, as Vincent pointed out, with regards to some of the charges, intent isn't even necessary. And that's something that contradicts a lot of what we've seen on the news over the last month or two. Intent isn't necessary for a lot of those charges. 38-count indictment. So it is for some, but not for all. And given the complexity and the severity of these charges and the penalties they bring, doesn't matter. 5, the question of weaponization will be answered if other presidents are charged with the same crime as Biden, such as Biden, okay? That's the question mark right now. Is he going to be? Is he not going to be? A lot of people are asking that. All I can tell you is don't get tied up in looking at that question. Focus on the case at hand. And the case at hand, you have the facts on. Last but not least, why this has everything to do with your personal safety. Those documents protect you. That information are our deepest, darkest secrets, information that is not meant to be public knowledge. And unfortunately, if the allegations are correct, your personal safety was compromised. Bottom line, that's a fact. It's not an opinion. So we need to be careful in really putting our arms around this case. I am not, in any way, shape, or form, a fan or an enemy of former President Trump at all. I think while he was president, he did some really great things. And, He did his share of dumb things. Whatever. Doesn't matter whether you like him or not. It matters what the facts are, and the facts are very plain. Was he in possession of it? And for the other charges, was there intent? Are there witnesses? Are there audio tapes? Those, ladies and gentlemen, are the facts. Those are the ones that you need to concentrate on when it comes to this case. So, jury's out. We'll see what happens in the months to come. But as Vincent said, and I'll reiterate, the penalty for this is severe. Comment below on today's episode if you can. Remember, always hit us up at info@factbasednews.com with any questions that you have. You can catch us on Twitter, Rumble, or BitChute. Social media, we're on Instagram, Facebook, and Twitter. And next week, please tune in. We're going to be talking about some eye-opening facts about sanctuary cities. I'm Paul Viollis, and this is Fact-Based News.